Listen carefully because what I'm about to share with you could fundamentally change everything you thought you knew about citizenship, immigration, and the future of your family in America. Right now, at this very moment, millions of families across the United States are waking up to a reality they never imagined possible. Parents holding newborn babies in hospital rooms are being asked questions that would have seemed unthinkable just months ago. Immigration attorneys are fielding emergency calls at unprecedented rates, and families who believed their path to American citizenship was clear are now facing uncertainty that keeps them awake at night. This isn't speculation. This isn't fear mongering. This is happening right now. And if you or anyone you love has any connection to the American immigration system, you need to understand what's unfolding before your eyes. Welcome to U.S. Visa Updates, where we cut through the noise, break down complex immigration changes, and give you the clear, actionable information you need to protect your family's future. I'm here to walk you through one of the most dramatic transformations in American immigration history, a shift so profound that legal scholars are comparing it to watershed moments that redefined what it means to be American. Before we dive deep into this critical topic, I need you to do something that costs you absolutely nothing, but means everything to our mission of keeping families informed. Hit that subscribe button right now. Click the notification bell so you never miss an update that could impact your immigration journey. And if you find value in what we're sharing today, leave a comment below telling us how these changes are affecting you or your community. Your engagement helps us reach more families who desperately need this information. Now let's get into what's really happening across America. Imagine for a moment that you're a parent. You've been living in the United States for years, maybe working legally on a visa, maybe studying at an American university, maybe even running a business that employs American workers. You followed every rule, filed every form, paid every fee. Your baby is about to be born on American soil, and you've always believed, like generations before you, that your child would automatically become an American citizen the moment they took their first breath in a U.S. hospital. That certainty, that fundamental promise that has existed for over a century, has been shaken to its core. What was once automatic, simple, and universally understood has suddenly become conditional, complicated, and deeply uncertain. Clears throat. The principle we're talking about is called birthright citizenship, and for more than 125 years, it operated on a beautifully simple premise. If you were born on United States soil, you were an American citizen, period. It didn't matter if your parents were tourists visiting from another country, students studying at an American university, workers here on temporary visas, or even individuals without legal documentation. The location of birth determined citizenship. This wasn't just policy. It was woven into the fabric of American identity, rooted in constitutional interpretation, and reinforced by more than a century of legal precedent. Hospitals didn't need to investigate parental immigration status. Families didn't need to worry about documentation. Children born here were Americans, and that was that. But everything has changed. A sweeping executive directive has fundamentally reinterpreted how citizenship at birth is determined. And the ramifications are spreading like shockwaves through every hospital, every immigration office, every family planning center, and every community with immigrant populations across the entire country. Under this new framework, automatic citizenship is no longer guaranteed simply by being born on American soil. Instead, the legal status of the parents has become the determining factor. According to the updated policy, a child born in the United States now receives automatic citizenship only if at least one parent holds one of two specific statuses. They must either be a United States citizen themselves or they must be a lawful permanent resident, which means they hold a valid green card. Think about what this means in practical terms. If both parents are in the country on temporary work visas, even if they've been here legally for years, their child born in America may not automatically receive citizenship, If both parents are international students attending American universities, contributing to American academic institutions, and paying American tuition, their newborn may face the same uncertainty. If both parents are asylum seekers waiting for their cases to be heard, tourists visiting the country, or individuals without current legal status, their children born on U.S. soil are now caught in a bureaucratic maze that didn't exist before. This isn't targeting any one nationality, any one culture, or any one region of the world. This change affects everyone equally, regardless of where they come from or why they're here. The moment this directive was announced, federal agencies received orders to immediately stop issuing automatic citizenship documentation to children who don't meet the new parental status requirements. Hospitals across the nation, which had followed the same straightforward procedures for generations, suddenly found themselves on the front lines of immigration enforcement. Medical staff who specialize in bringing new life into the world are now being asked to verify immigration status, review documentation, and navigate legal questions they were never trained to handle. Birth certificates that once represented pure joy and new beginnings now come with questions about green cards, naturalization certificates, and legal immigration status. State agencies that manage vital records and citizenship documentation have been forced to rapidly adjust systems and procedures that hadn't changed in living memory. What used to take minutes now requires interviews. What used to need basic information now demands extensive documentation. What used to be certain now requires verification, review, and often legal consultation. The administrative burden alone is staggering, but the human impact is even more profound. Parents who had absolutely no reason to worry before are now consumed with anxiety. They're asking questions that would have seemed absurd just months ago. Will my baby be recognized as an American citizen? What documents do I need to bring to the hospital? How will this affect my child's ability to enroll in school, to get a passport, to access health care, or other benefits? And perhaps most heartbreaking of all, some parents are facing a fear that seems impossible in modern America. Could my child become stateless, belonging to no country at all? The confusion that erupted nationwide was immediate and intense. Within days of the directive being announced, legal challenges began flooding into courtrooms across America. Civil rights organizations mobilized rapidly, arguing that such a fundamental change to citizenship policy couldn't be implemented through executive action alone. Immigration advocacy coalitions joined forces with constitutional law experts to challenge the legal foundation of the directive. Several state governments, recognizing the chaos unfolding within their borders, filed their own lawsuits arguing that this dramatic transformation required full legislative action from Congress, not just an executive decision. For a brief moment, it appeared the entire policy might be blocked before it could take effect. Multiple federal district courts issued temporary restraining orders and preliminary injunctions, halting implementation in specific jurisdictions. This created an incredibly confusing patchwork of rules across the country. In some states, hospitals continued operating under the old system, automatically recognizing all children born on their soil as citizens. In other states, the new verification procedures went into full effect immediately. Families living in mixed status households, which is incredibly common in immigrant communities, found themselves in complete limbo. A child born in one state might be recognized as a citizen while their cousin born on the same day in a neighboring state faced entirely different treatment. The inconsistency was maddening and the uncertainty was crushing. Then came the moment that changed everything. The Supreme Court of the United States stepped into the controversy, not to rule on whether the policy itself was constitutional, but to address a different but equally important question about judicial authority. In a decision that sent shockwaves through the legal community, the court determined that individual district courts do not have the power to issue nationwide injunctions against federal immigration directives. This technical ruling had enormous practical consequences. Almost immediately, many of the temporary blocks that had paused implementation were lifted. The directive was suddenly enforceable in the vast majority of states, though a small handful of jurisdictions maintained temporary protections due to ongoing state level lawsuits and different legal theories. Essentially, what this means is that the policy now stands and is being actively enforced across most of America. Even though the broader constitutional and legislative fight is far from over, legal scholars expect this battle to continue for years, potentially returning to the Supreme Court for a definitive ruling on the underlying constitutional questions. But in the meantime, families can't wait for legal clarity. They're living with this new reality right now today in hospital delivery rooms and immigration attorney offices across the nation. The effects of this transformation are being experienced very differently depending on where families live. In states where enforcement remains on pause due to ongoing legal protections, families feel a temporary sense of relief, though always shadowed by the knowledge that the pause could end at any moment. But in states where the directive is fully active and being enforced, the shift is being felt deeply and personally. Hospitals must now confirm and verify parental immigration status before they can issue citizenship paperwork for newborns. Parents are required to present green cards, naturalization certificates, passports with valid visas, or other proof of legal immigration status. Families who don't have immediate access to these documents, whether because they're lost in process or never existed in the first place, face an uncertainty that would have been unimaginable just 1 year ago. Community organizations serving immigrant populations have reported receiving an absolutely unprecedented number of calls from worried, frightened, and confused parents. These aren't people trying to game the system or take advantage of America. These are families who are genuinely trying to understand what steps they need to take, how the new rules actually work, and how they can plan for their children's futures in this dramatically changed legal landscape. Immigration attorneys who already had full caseloads are now completely overwhelmed. Nonprofit legal networks that provide services to low income immigrants are stretched beyond capacity. Advocacy groups have begun hosting emergency workshops, information sessions, and legal clinics to help guide families through what has suddenly become an incredibly complicated process requiring expertise that most people simply don't have. The ripple effects extend far beyond the delivery room. Schools are grappling with questions about enrollment for children whose citizenship status is now unclear. Healthcare providers are uncertain about eligibility for various programs and services. Parents are worried about obtaining passports for family travel or even basic identification documents. The bureaucratic complications are endless. But behind every complication is a real family facing real consequences. And just when families thought they had enough to navigate, another seismic shift has emerged in the American immigration landscape. This time, the changes are affecting family based immigration. The process by which United States citizens and green card holders sponsor their immediate family members to come to America or adjust their status if they're already here. At the heart of this process is a form known as the I-130, officially called the Petition for Alien Relative. For decades, this form has been the gateway for family reunification, allowing Americans to bring their spouses, children, parents, and siblings to join them in the United States. The I-130 petition used to focus primarily on one central question: is this a genuine family relationship? Petitioners needed to prove that marriages were real and not just immigration schemes, that parent child relationships were legitimate, that sibling connections were documented. It was thorough, yes, but the focus was clear, and the process, while never easy, was at least well understood by immigration attorneys and families who had been through it before. That process has now evolved into something much more extensive, much more demanding, and significantly more complex. Applicants are reporting that the forms themselves have grown substantially longer, with expanded questionnaires that probe into areas that weren't examined nearly as deeply before. The requests for supporting documentation have multiplied far beyond what was previously required. Financial disclosures that used to be relatively straightforward now demand detailed information about income sources, assets, debts, employment history, and sometimes even the financial situations of extended family members. Relationship evidence that used to consist of wedding photos, joint bank account statements, and affidavit from friends and family now requires much more comprehensive documentation, spanning longer time periods and covering more aspects of the relationship. Background checks, which were always part of the process, have intensified significantly. Investigators are looking more carefully at employment history, travel patterns, previous immigration violations, even minor ones, criminal records, even for offenses that wouldn't typically disqualify someone, and any discrepancies in previous applications or statements made to immigration authorities. The level of scrutiny has increased across the board, and processing times, which were already frustratingly long before these changes, are now expected to stretch even further. Families who were already waiting months or years for decisions may now face even longer separations from their loved ones. These enhanced requirements apply across the board to all family-based petitions. It doesn't matter if you're sponsoring your spouse who you've been married to for 20 years, your minor child, your elderly parent, or your sibling. Everyone faces the same increased level of examination. Government officials describe these changes as necessary measures to protect the integrity of the immigration system, to prevent fraud, to ensure that people entering the country through family sponsorship are genuinely qualified and won't become public burdens. But many families and their advocates fear that reunification, which is supposed to be one of the core principles of American immigration policy, is becoming more difficult, more expensive, and in some cases nearly impossible, especially for immigrants who lack substantial financial resources, access to quality legal representation, or the ability to obtain detailed historical records from their home countries, where record-keeping systems may be unreliable, able, or even dangerous to access. This shift in family-based immigration policy, much like the change in birthright citizenship, signals something larger than just administrative adjustments. It represents a fundamental philosophical transformation in how the United States views immigration itself. The changes reflect a clear move toward increased regulation at every level, toward demanding documented proof for every claim, toward careful examination and verification of every detail of every application. The question of whether these changes will ultimately bring the stability and security that officials promise, or whether they will create new challenges, new backlogs, and new hardships for American families, is something that only time will reveal. As court cases continue to wind their way through the federal judiciary, as new legal arguments are developed and tested, as families adapt to these new realities, and advocates push back against policies they consider unjust, one thing remains absolutely clear beyond any doubt. America is experiencing a genuine turning point, a moment that historians will look back on as pivotal in shaping immigration policy, citizenship law, and family unity for generations to come. The full effects of these policies won't be felt overnight. They won't even be fully understood in the coming months. Instead, they will unfold slowly and steadily across schools where children enroll, hospitals where babies are born, workplaces where immigrants contribute to the American economy, and every corner of the vast and complex immigration system that touches millions of lives. For families who are currently navigating visa applications, for those preparing sponsorship petitions for loved ones, for expectant parents planning for the birth of a child, staying informed has never been more critical. Knowledge is not just power in this environment. Knowledge is protection. Understanding the current rules, knowing what documentation you need, being aware of your rights and your options. These things may be the difference between a successful immigration outcome and a devastating denial. These changes don't only affect the present moment, they are actively shaping the future trajectory of the nation, determining who becomes American, how families stay together, and what the United States will look like in the decades to come. And as new proposals continue to surface, as the political landscape continues to shift, as court decisions continue to be handed down, one thing is certain beyond any shadow of doubt. The immigration landscape of the United States is changing rapidly, dramatically, and in ways that will have profound consequences. Understanding the rules as they exist today, right now, in this moment, may very well be the key to protecting your family's future, preserving your path to citizenship, and ensuring that you don't become another casualty of a system in flux. This is why channels like US Visa Updates exist. This is why we're committed to bringing you clear, accurate, timely information about every development that could impact your immigration journey. We're not here to tell you what to think politically. We're here to help you understand what's happening legally, what it means practically, and what you can do to protect yourself and your loved ones. If this video has opened your eyes to changes you weren't aware of, if it's answered questions you've been afraid to ask, or if it's helped you understand the bigger picture of what's happening in American immigration, then please take a moment right now to like this video, share it with anyone who might need this information, and leave a comment below telling us what immigration topics you want us to cover next. Your engagement helps us reach more families, and together we can build a community of informed, empowered immigrants who understand their rights and their options. Subscribe to US Visa Updates, turn on notifications, and stay informed. Because in this rapidly changing landscape, knowledge isn't just